All right, who started the class without me? Just kidding. Hey, welcome. Let's see, we got 28 people in attendance. So I guess everybody knows by now that I always start a minute or two behind the 5:45 clock. The reason I do that is, uh, when you're live, you can get there early. You can anticipate the traffic. You can be here on time. But I know how it is with this coronavirus, with the self quarantine, with the distractions with working from home. If you're like me and you got little ones, you remember my 10-year-old Patrick, my 7-year-old Madeline. If that's a challenge to both participate in their day-to-day education all day, every day, and to work from home at the same time. I know each of you are facing at least those modicum of challenges and probably so many challenges that are so greater. For that reason, I start a couple minutes after 5:45. Hope you don't mind. But hey, welcome everyone. If you were with us last week, which the majority of you were, you saw your fellow alumna doing a great job teaching class. And I thought she did a wonderful job of helping everyone to understand what exactly is required for answering the constitutional law question on the constitutional law exam. So I hope that was helpful to you. Got an email in my inbox, haven't had a chance to answer it yet, from a former student from about 2 years ago who just shared with me the great news after taking my class. My former student passed the Florida bar exam. So Lord willing, I'll be getting plenty of emails like that from each and every one of you with the good news that the bar exam of your choice was one that you blew away and passed without any difficulty. And hopefully I can do my part to help you with that. So welcome back. And for many of you, you're celebrating Passover. A blessed Passover to each of you. Many of you celebrate Easter Sunday like I did on Sunday, and that makes today Easter Tuesday. So hope your Easter is going well also. Here in law school, we're taught methods of finding the truth. And when it comes to trial work, the primary method of finding the truth is through the testimony of the witnesses. I'm sure as you all, or at least 2 L's, most of your 3 L's, you've noticed that this is how a trial lawyer does the job of finding the truth. It's through the testimony of the witnesses. Of course, there's documentary evidence, but how often does a document get in without the testimony of a witness? Very rarely. Of course, there's the CSI effect and there's the science, but how often is the science presented and explained through the testimony of a witness? Most of the time. So we lawyers find the truth through the testimony of the witnesses. And the more time we have to do that, the better job we can do of cross-examination, figuring out the truth from the lies. The more technology we have in this whole profession of ours, as time has gone on, technology has improved and it's made it easier, better for us lawyers to find the truth through the testimony of the witnesses. And that's why, in my humble opinion, Easter is such a beautiful time for a lawyer, because despite the passage of time, despite the improvements of technology, despite empires who have risen and fallen over the past almost 2,000 years, so many money and despots and individuals have had the incentive to try to disprove the testimony of the witnesses. But there's 3 common facts that the witnesses testify to that, despite 2,000 years, have not been disproven. Those 3 proven facts: Christ has died, Christ is risen, Christ will come again. So with that in mind, I want to start this class the same way I start every class. I want to start with a prayer. I want to send this prayer out to you and for you. I'm praying for your success in your future bar exam. I'm praying for your health and safety right now during this difficult time. And I'm praying that I do a good job and help you along the way. With that said, in the name of the Father, and of the Son, and of the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. and lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, we fly unto you, O Virgin of Virgins, our Mother. To you do we come, before you do we stand, sinful and sorrowful. O Mother of the Word incarnate, despise not our petitions, but in your mercy hear and answer us. Jesus, I trust in you. Jesus, I trust in you. Jesus, I trust in you. In the name of the Father, the Son, and the Holy Spirit. Amen. Well, welcome back, everyone. Today, we have just a few more minutes left to finish our discussion of homestead. And after that, we'll talk about taxation and finance. You're excited about talking about taxation. I wish I could share your excitement, but nevertheless, we will cover it. There was a time long, long ago, late 70s, early 80s, you could rely on the Florida bar exam to test you on the topic of taxation and finance. For that reason, there's quite a popular book, not the one we use here in our class, that was written in approximately that time and has carried forward the practice of teaching taxation and finance. Now, again, nowadays it's quite rare, quite unusual to find any emphasis on state and local taxation on the Florida bar exam, but at least in theory, it could be there. Likewise, if you took the class and used the other book, approximately 2 out of every 5 pages in that book, approximately 40% of that book is dedicated to that topic. Personally, in my humble opinion, that's too much emphasis. So, especially in a state where there is no state income tax, as you know, Florida is known as a tax haven. So I hope I've made the right decision. I hope I've put the proper emphasis, the proper amount of emphasis on state and local taxation. On your exam in my class, you will be tested on what we complete and cover today out of our state and local taxation chapter. What we don't complete and don't cover today out of our state and local taxation chapter, you will not see on my particular exam. Might you see it on the Florida bar exam? Well, I'll give you about a 99% chance that you won't, but there is that 0.9% chance that you might. So you might want to just explore my chapter in greater depth. My chapter, in my humble opinion, does certainly an adequate and probably a great job of covering anything and everything you need to know for the Florida bar exam. And I think my lecture, although it doesn't cover everything in the chapter, will do the same. So that will be a taxation. I hope you find a way to stay awake through it. In the meantime, let's talk about homestead, shall we? And we've already covered homestead in such great detail, but let's call this a brief outline of what homestead means to us, the relevance of homestead, the different parts of homestead that we're looking at. The Constitution of the State of Florida protects a Floridian's homestead in 3 distinct ways. And the first there, it gives a partial exemption from certain real estate taxes. Can you still lose your home, lose your homestead for failure to pay taxes? Yes, absolutely. Can you lose your home, lose your real estate, lose your homestead for failure to pay your Florida real estate taxes? Yes, absolutely. But the sum total of what those taxes would be owed to the state of Florida is a lower sum total for a homestead than it would be for non-homestead real property, because the homestead exemption, the first of the 3 things it does for us, is it lowers that Florida real estate tax bill. The second thing it does, it prevents a forced sale in favor of most creditors, not in favor of all, as we discussed previously and we'll continue to discuss now. But when it comes to forced sale, when it comes to creditors, they can't force you to sell the homestead unless they meet one of the exceptions. And the third thing that homestead does for us, it prevents the owner from bequeathing or devising the property to those who are not, in a way, related to the owner. I left you with our last lecture wondering exactly how many sticks in the bundle must I own? What relationship must there be? Today, I answer those questions for you. So that's where we're going. Let's take a look specifically now at that third element, preventing the owner from bequeathing or devising the property to those who are not related to the owner. And in answering that question, let's take a look at the case of Snyder versus Davis. Now, Kaylee Stouse did a fantastic job being a guest lecturer last week and being by my side. And she mentioned on more than one occasion IRAC issue, rule, application, conclusion. In honor of her great work that she did for us, let's look at the IRAC of Snyder versus Davis. First, the issue in that case: mom disinherits her adult son. So the son is far more than 18 or 21 years of age. He is an adult. He is independent. He is sui juris, if you will. And instead of leaving mom's homestead, dad is predeceased, mom is a widower. Instead of leaving mom's homestead to her adult son, and she has no surviving spouse, she instead leaves the homestead to her granddaughter. Do folks do this sometime? Talk to any estate planning attorney, and the answer will be yes. So this is a realistic, factual scenario. This happens. This happened here. This could happen in your practice. Now, the personal representative, which is what Florida calls our executor or executrix, we give that job the gender-neutral title of personal representative, or PR to abbreviate it. The PR has a plan. The estate is indebted. Liquid assets can't pay those debts. The PR proposes to sell the homestead. How can this forced sale, if you will, take place? Isn't this protected from forced sale by a personal representative? The answer is it can be. A personal representative's decision to sell can be a forced sale. And under the facts of Snyder versus Davis, it certainly was, because the granddaughter objected to this plan. Why then does the PR think the PR can do it? Well, the definition of heir and the statute at the time said that the adult son would have been mother's heir. Indeed, even under the intestacy statute, if mom had never written a will, the adult son would have inherited the house. So, argues the PR, homestead should not apply here, argues the PR, because, the PR argues, an heir did not inherit. The heir, says the PR, was the adult son and not the granddaughter. So that was the argument. What is the rule? An owner without a surviving spouse or minor child may bequeath the homestead to any heir, and if so, the homestead protection survives. The homestead remains protected under Florida's homestead law. Heir includes anyone named in the intestacy statute. Any one. So here, under the intestacy statute, there might have been an argument for inheritance for two people, or three, or four, or five in a different set of facts. But the rule is, as a Floridian drafts the Floridian's estate plan, the Floridian can choose just one heir or several, and can exclude other heirs, even if those individuals would have inherited, but for the will, would have inherited if there was intestacy. You recall the definition of intestacy means dying without a will or estate plan in place. So here, the rule is that you can pick and choose. And indeed, in Snyder versus Davis, that's what the widowed mother of the adult son did when she disinherited the adult son in favor of the grandchild. So the application here, both granddaughter and adult son are named in the intestacy statute. Mom picked the granddaughter, and nothing requires otherwise. That brings us to this conclusion. Granddaughter inherits the homestead free and clear of creditors and avoids the forced sale by the personal representative. That's the result of Snyder versus Davis. The PR cannot sell the homestead under these facts. Why not? Because it is protected under Florida's homestead laws as they have been written pursuant to Florida's Constitution. So here, the forced sale is avoided. Granddaughter inherits the house. What about the creditors? Remember, deceased mom's estate was insolvent. It owed more money than it had assets when we do not count the homestead among its assets. Well, to the extent those creditors can be paid, they will be. But to the extent that the money runs out without counting the value of the house, because it's not a probate asset under these facts, those creditors will be insufficiently paid. Their debts will not be fully paid. They may even go, under certain facts, away empty-handed. So, is a homestead part of a probate estate? No, it's not. If you're an estate planning attorney in Florida, one of your options when you're probating the will is to, at an appropriate time, sometimes shortly thereafter, file a motion to determine homestead. If the motion is granted and the judge adjudicates that the real property was homestead, then it is not an asset of the probate estate. It can't be sold and used to satisfy the claims of creditors. Instead, the order determining homestead will determine who is the owner, and those individuals will now own the homestead free and clear of the estate's debts. And no forced sale is available to the creditors to try to get at any part of the equity of that real property that has been found to be homestead. So that's the value of what we're talking about here when we talk about homestead. When we say that it's exempt from forced sale to creditors, what we're saying is that rightful debt owners, rightful creditors can go away underpaid or empty-handed, and heirs can get a house free and clear of certain debts. You remember from last week, some of the debts that didn't apply: taxes, purchase money, mortgages, liens for improvements upon the house, be it as sophisticated as a new roof or as simple as a handyman who patched the fence. So we're not talking about any and all debts. But don't underestimate the value. We are talking about the credit cards. We are talking about the personal loans. We are talking about the tortfeasors. What if, God forbid, in this particular set of facts, the individual passes away after having been a tortfeasor? For example, having caused an automobile accident, caused a slip and fall, caused a medical negligence, caused some tortfeasor's victim to suffer thousands, tens of thousands, or $1 million in damages. Despite that claim, the heirs will inherit the homestead free and clear of those types of liabilities. So don't underestimate the power of the homestead exemption. What becomes of the homestead if the deceased is not survived by a spouse or a minor child? Homestead protection is lost unless the deceased estate plan devises the homestead solely to one or more of the deceased family members who fall within the class of persons named in Florida's intestacy statute. That is the holding of Snyder versus Davis. But let's not read it too broadly, because of how the intestacy statute reads. If we take a look at the intestacy statute, just about anybody related to the deceased falls within the intestacy statute. What about your good buddy, your good friend? No, No, your good buddy, your good friend doesn't fall within the intestacy statute. But who does? Let's take a look at the intestacy statute. That's 732.103 Florida statutes. Here's who they name. Any one of these individuals can get a homestead free and clear of the deceased's eligible debts. Any descendant of the deceased. So what's that mean? Any child, any grandchild, any great-grandchild, any great-great-grandchild, any adopted child, any adopted grandchild, any adopted great-great-grandchild. But that's not all. That was number one. Look at number two. If there's no descendant, and that was a ridiculously long list, if there's no descendant, then to the decedent's father and mother equally, or to the survivor of them. So the deceased mom or dad. If none of them are alive, then to the deceased brothers and sisters and the descendants of the deceased's brothers and sisters. So the niece and nephew, the children of the niece or nephew, the grandchildren of the niece or nephew, the great-great-grandchildren of the niece or nephew. Number four, if there's none of those, and already we've listed dozens of individuals, we've even included cousins already. But if there's none of those, the estate shall be divided. One half shall go to the deceased's paternal, the other half to the deceased maternal kindred in the following order, to the grandfather and grandmother equally, or to the survivor of them. So they can get a homestead. If there's no grandfather or grandmother, to the uncles and aunts of the grandfather or the grandmother, so they can get a homestead. If there's none of those, then to any other kindred who survive that are kindred of the maternal kindred or the paternal kindred. My God, this is second cousin, third cousin, fourth cousin. If there's no kindred of either part, the whole of the property goes to the kindred of the last deceased spouse. So now we're related by marriage, not blood. As if the deceased spouse had survived the decedent and then died intestate. If none of those, if any of the descendants of the decedent's great-grandparents were Holocaust victims, then to either them or any descendants of them. So you see just how far removed you can continue to be, and you still get a homestead free and clear of the eligible debts that don't prevail over homestead. So now to wrap up Schneider versus Davis, Note 1 and Note 2 summarized some points of law that were seen in Schneider versus Davis. Note 3 asks this question. On that ridiculously long list of potential heirs under the intestacy statute, who on earth is left out? Well, we know your buddy's left out. But can we think of anybody else? I don't know, your buddy's neighbor, your buddy's neighbor's mailman. If there's a shred of blood or marriage relationship between you and the individual you've decided to leave your homestead to, they're going to get the homestead. They're going to get it free and clear of the debts. So that's the holding of Schneider versus Davis when we interpret it in light of how broadly written Florida's intestacy statute is. Now, another unanswered question I left for you last week had to do with the bundles of sticks. You took property law in your 1L, perhaps maybe 2L class, and you were indoctrinated, educated to believe that property is a bundle of sticks and the question of ownership is a question of how many of these sticks in the bundle you own. So to carry that question forward to Florida's homestead law, what kind of ownership do you need? Can you be the part owner? Let's take a look. We looked at 3 different types of potential co-owner situations. The first we looked at was tenancy by the entireties. What does that mean? That means owned as spouses. Spouses are eligible for this type of co-ownership and co-owners. For tenants by the entirety, each owns an undivided 1/2 interest. So they each own the whole. It hasn't been divided. They each own the whole. So now what's the answer here? What's the takeaway? What should we say about tenants in the entirety? Provided either spouse, just any one of them, provided either spouse qualifies for the homestead creditor exemption, then the property will be afforded protection from either spouse's creditors. So we just need one to meet homestead, and if so, then that's going to afford homestead protection from not only that one spouse's creditors, but from the other spouses too. Those creditors that are eligible to have their debts reduced or eliminated by the homestead. Let's look now at a different type of co-ownership. Here we have tenants in common or joint tenancy with rights of survivorship. The author we quote from, Joe Percopo, tells us here that unless specific language is used indicating survivorship rights, tenants in common is the default form of these two. So unless you spell out the survivorship right, you'll find yourself as a tenant in common. But let's combine the two now for the purpose of analysis under the homestead law. Generally speaking, either one of these types of co-ownership of property will not prevent an owner from claiming the homestead creditor exemption. When all co-owners qualify for the homestead creditor exemption, the home will be exempt from forced sale and liens. If any one of the co-owners does not qualify for the homestead creditor exemption, a creditor of that particular co-owner can acquire an interest and then force a sale, a partition action, which involves the sale of the property. Property will be completely shielded from creditors when all the tenants in common, all the joint tenants with rights of survivorship, all those types of co-owners qualify for the homestead creditor exemption. However, if at least one co-owner does not qualify for the homestead creditor exemption, the property becomes subject to that co-owner's creditors. So what's the lesson? What is the takeaway here? Tenants in common and joint tenancy of rights of survivorship is different than tenancy by the entirety, is it not? Tenancy by the entirety is if one of the co-owners, who are spouses by definition, if one of the co-owned spouses qualifies, then creditors of either spouse may find themselves out of luck and unable to force the sale. That's not true for tenants in common or joint tenancy right of survivorship. There, if any one of the co-owners can't meet the homestead requirements, then the creditors of that co-owner can execute upon the co-owner's interest. To do that, you need an action called a partition, ultimately. But ultimately, the takeaway point is that you can have a forced sale here in circumstances where you couldn't have a forced sale there. Let's look at a third type of co-ownership. Here we have a life estate. And this type of co-ownership differs from the other two, as you remember from your property law class, in that we have one owner at a time. What I mean by that is the first of the co-owners, or the first of the group of co-owners, is a present possessory interest. They have the property and ownership rights, which are limited. They can't destroy the property or make improvements upon it without the remainder persons approving of that. But putting those property law issues aside, the takeaway for our purposes is that the life estate is owned now by that group, but after their death will be owned later by the remainder persons. So who here can claim the benefits of homestead? Well, if you think about it, the remainder persons, they don't live there right now. How are they going to claim that it's their homestead if they don't live there? And indeed, that's a practical purpose a practical problem with a real life effect, being that they do not get to claim homestead. So that's not going to protect the remainder persons, remainder men, remainder women. But the life estate, they can claim protection. The book puts it this way. A life tenant, that's this one, a life tenant can qualify for the homestead creditor exemption with a life estate, but the Florida Supreme Court has determined that a remainderman cannot qualify with a remainder interest. Therefore, a life tenant could continue to reside on the property without worrying about the remainderman's creditors being able to force the sale of the property. That's a good point there at the end. So that sums up those 3 or 4 major types of co-ownership. Bottom line is, if I'm just a co-owner, am I entitled to homestead if I just have the bundle, the stick in the bundle that's co-ownership? Yeah. If I'm a co-owner but just a life tenant, I just have those or that stick in the bundle, can I get homestead protection in Florida? Yeah. Homestead is broadly construed to protect the homesteader. That's a theme you find throughout the case law, and certainly a theme you see in Quiroga versus Citizens Property Insurance, with all due respect to Kaylee Stouse and all those that love the IRAC method. I much prefer to take poetic license when I talk about a case. I'll pretend that I somehow have read all the briefs and I know the parties or whatever other excuse you'd like for my poetic license. But allow me once again to take poetic license with the facts of Quiroga versus Citizens Property Insurance in such a way that it's memorable and that it highlights for you the 2 take-home points that I don't want you to miss. The first being that homestead is not concerned with equity or fairness. And the second being that the sale or proceeds or insurance recovery that arises out of a homestead, those proceeds themselves are protected by homestead. So to illustrate those 2 points, well, a little poetic license, if you would. So there's a home here in Florida and it's damaged by the wind, it's damaged by the hurricane. My gosh, it seems like that happens almost every year lately, doesn't it? And you've seen the billboards, you've heard the advertisements. Do you have a windstorm claim? Do you have a hurricane claim? Call us. No fee, no cost, and no recovery, says the lawyer's advertisement. And indeed, that was the advertisement they answered. The Florida Bar has a standard contingency form contract, and the attorneys dotted their I's, crossed their T's, followed the bar rules, used the standard contract. Their potential client was not yet a client, had the opportunity to read and understand that contract, had the opportunity to get legal advice before entering into that contract, knowingly and willfully entered into the contract, agreeing to pay the standard contingency recovery. Let's say here it was 33% before trial, 40% after. And let's say here the lawyers knocked it out of the park, did a great job, managed to recover the full amount possible under the insurance proceeds. That's right, the policy limits were tendered even before filing suit. Into the lawyer's trust account it goes. Good news, says the lawyer in the letter. Enclosed is a check for 66% of the entire policy limits. Thank you for hiring us. We're happy to have won the claim for you, and pursuant to the contract, we get 33%. The client calls up not to say thank you, not to say job well done, but to say, give me the rest of the money, says the client. I want 100%. But you signed a contract, explains the lawyer, and I did my part of the contract. I got the maximum recovery under that insurance policy. You promised to pay me 33%. Yeah, I did, says the client. So I get 32%, says the lawyer. No, you don't, says the client. What? Says the lawyer. and does what any good and ethical lawyer does when there is a dispute over insurance proceeds or any other type of contingency recovery. The lawyer, if already taken out of the trust account, returns the fee to the trust account, the lawyer's own trust account, where the money stays safe and sound, while the lawyer does what? Goes to court, preferably, usually on an action for declaratory judgment, asking the court to decide who gets the money in the trust account. So remember that if you ever want to do any contingency work, you can follow the terms of the contract, take your fee. But if your contingency client then complains, what do? Under the rules regulating the Florida bar, you put your fee back in your own trust account. And then you are proactive. You go to court. You start the lawsuit. You get the judge to decide that the fee is yours. And is that ultimately what Florida's Third District Court of Appeal did? Did the third DCA say, yeah, that was a valid contract? You get to keep the money in your trust account? No. First, why did the third DCA say no? Was it because it was money and not a home? That was not the basis. As I mentioned in the preface of this talk, not only is the home protected, but money that derives from the sale of a homestead or that derives from insurance proceeds or other lawsuit recovery for damage to a homestead, that money is protected by Florida's homestead law. That's a great advantage for the Florida homesteader, because what if you want to sell your house and move into a different one? Assuming you're wise enough to be able to show the source of the money, such as by segregating it into a separate bank account, for one example, and assuming you're wise enough to move into a new house within a reasonable time, there's not a firm time limit. The question is, are you still searching, or did you just give up? Assuming you move into a new house within a reasonable time and you're continuing your search, then the sale proceeds remain protected from creditors, just like the homestead was. Same is true if someone damages your property and has to pay a claim on it. Same is true if the insurance company in a windstorm, like we see here in Quiroga versus Citizens Property, those proceeds were protected by the homestead. Was it fair to say, lawyer, you get nothing, client gets 100%? Absolutely not. It was not fair, but it was the correct outcome, because the result of the lawyer's efforts was to recover homestead protected property. And that homestead protected property is protected from the claims of creditors. At this point, the lawyer became a creditor. So what's the lesson? What's the takeaway? First, if you liquidate the home or you get some liquidated damages for damage to the home, they too can be protected by the homestead. And second, homestead law in Florida is not concerned with equity or fairness. The result isn't what's equitable or what's fair. The result is what the law says under those facts. And under these facts, as fellow lawyers, or maybe your future lawyers, I'm sure you'll agree that a lawyer who deserves to be paid should get paid. But here the lawyer does not. Is that fair? No. Is that equitable? No. Is that the result, the correct result under Florida's homestead? Yes. Yes, it is. So that wraps up our discussion of homestead. Now let's turn to taxation and finance. And it's a strange thing, isn't it, that we find ourselves discussing taxation and finance in a state that most U.S. citizens would consider a tax haven. There are very few states that say there's no income tax on the state level. But Florida is one of those very few states that say that. If you live here in Florida, you don't pay an income tax. Compare that to other places. There, you might not only pay a state income tax, you might even pay a local income tax. That's not allowed in Florida. But in other states that have state income taxes, they might have local income taxes too. I remember many years ago, my sister was living in Staten Island, New York, commuting to Manhattan, New York. She filed a tax return, of course, with the federal government every year, Form 1040, federal income tax. She also filed an income tax return with the state of New York every year, had to pay tax on that same income that she already paid taxes to the federal government. She also had to file an income tax return with the city of New York, in addition to the tax return she filed with the state of New York, in addition to the tax return she filed with the US federal government. All three sovereigns taxing her on that same paycheck. Indeed, since at the time she was a W-2 employee, those taxes went to those sovereigns before she ever got a hand on it. The federal withholdings were withheld, the state withholdings were withheld, and the city income tax withholdings were withheld. So when we're called a tax haven here in Florida, try to see that in the perspective of other individuals who are living in other states. They're paying quite a bit more in taxes than we are. So in Florida, protection from taxation is so important that it shows up in Article 1, our Declaration of Rights. You remember Article 1? It talked about freedom of religion, freedom of assembly, freedom of the press. And here in Florida, also talks about taxpayers' Bill of Rights. The legislature shall prescribe and adopt a Bill of Rights. What's in that Bill of Rights? It's exhaustive. Here's just 3 highlights. The right to request assistance from a taxpayer rights advocate. And this is not a powerless individual. Indeed, this taxpayer's right advocate has the statutory right to issue a stay order against the Florida Department of Revenue. Another, in the Taxpayer Bill of Rights, that was an enabling statute from Florida's Constitution. The right to be represented or advised by counsel, attorneys. Another, the right to have the taxpayer's tax information kept confidential unless otherwise specified by law. Building on our Florida right to privacy, which is in the text of our Constitution. It's not a penumbra or an emanation from Florida's Constitution. It's in the text of the Constitution. It's been interpreted by Florida Supreme Court in cases such as Winfield versus Department of Parimutuel Division of Parimutuel Wagering. I had no trouble saying parimutuel, but I had trouble saying wagering. But in a Winfield case, finding that there is a right to privacy in a Floridian's finances. Likewise here, the right to have your tax information kept confidential unless otherwise protected by law. I love to build on your knowledge of the federal Constitution, and you took Federal Common Law 1 by comparing and contrasting federal constitutional rights with state constitutional rights. When I do that, I inevitably stumble into politics. If your politics are different than mine, then I apologize for the difference. But of course, let me point out a difference here. Currently in the news, there is a fight, and I guess there's some oral argument before the Supreme Court of the United States taking place either this week or next about whether U.S. President Donald Trump's tax returns must be produced to those who requested them. We'll soon have that answer under the U.S. Constitution, but we clearly have that answer already under the Florida Constitution. The right to have a taxpayer's tax information kept confidential unless otherwise specified by law is within the Taxpayer's Bill of Rights. So if that case involved not the chief executive of the federal branch, called the president, but instead involved the chief executive of the state executive branch, called governor, the answer would be quite clear. Wouldn't need SCOTUS to get involved then. So what kind of taxes exist? What are they? What are they called? How do they work? Wow, this is going to be entertaining stuff, isn't it? Stay awake with me now, and let's talk about the type of taxes that exist. Let's talk about ad valorem taxation. Ad valorem taxation. I don't pretend to speak Latin, wish I did. Ad valorem, based on value. Isn't that how the Latin would translate? And indeed, ad valorem is a tax upon the value of the property. And that makes it quite heinous if you think about it. It makes it quite laborious. It makes it awful. If you think about it. Say you're blessed enough to have $10,000 to invest. Maybe you put it in the stock market. Or instead, maybe you buy a piece of real property. Now, after a year in the stock market, maybe you've made $2 in dividends. And maybe the value of the stock has gone up 3%. What do you owe taxes on? You owe taxes on that dividend check, the $3. Your $10,000 stock might be worth $10,030, but you know no taxes on $10,030. No. You owe taxes on $3, the dividend you saw. Compare that instead to the individual who invested the $10,000 not in the stock market, but instead in real property. That property goes up 3%. Now it's worth $10,030. Do you owe taxes on $30? No. You owe taxes on $10,030. 2 years have gone by. Person who put the 10 grand in the stock market, they got another $2 in dividends. So their stock is now worth $10,040, and they saw $2 in their pocket. What does that investor owe taxes on? $2. Same 10,000 invested in real estate. Now the real estate is worth $10,100. What does that investor owe taxes on? $10,100. Oh, McGinley, wait a minute. Last year he already paid taxes on $10,030. Shouldn't this year he just pay taxes on $70? No. He's going to pay taxes on that $10,000 again and again and again, year after year after year after year. Until when? When does it stop? I don't hear anything. And that's the correct answer. It never stops. It never stops. That $10,000 you managed to squeak and save, you're going to pay taxes on that $10,000 year after year after year after year after year. That's ad valorem taxation. That's how property taxes work. In a way, if you think about it, thanks to ad valorem taxation, do you ever really own a piece of property? Can you really? We talk about a bundle of sticks in the property class. Are you ever really the true owner of the property? What if you skip a property tax bill? They foreclose. They take your property away. Sure, eventually they'll sell it, and then they'll take the sales proceeds, they'll minus every expense they can ever come up with, and they'll give you a little bit back. But you've lost your property. Compare that if you'd put the $10,000 in the stock market. You didn't pay the taxes on the $3. Well, eventually you got to pay the tax on the $3 plus penalties and interest. But they're not going to take your stock away over $3, are they? Probably not. Anyway, you decide whether you're a fan of ad valorem taxation. Perhaps you can tell whether I am. So ad valorem taxation is a tax upon the value of the property. How do you calculate it? It's computed using a millage. Millage. What's a millage? A millage is the math you use based on a mill. What's a mill? A mill is the cost per $1,000 in value. So 1 mill, 2 mills, 3 mills. That's the cost per $1,000. And I don't want to misstate it. Spent a lot of time on this sentence, so I want to read it to you verbatim out of my book. To convert millage rates to dollar rate amounts, divide each mill rate by 1,000. Then multiply the result by the property's taxable value to compute the property tax. I don't want to confess how long it took me to write those 2 sentences, but I can't find a way to say it better than this. Maybe you can. I didn't find any source that said it better than this. Here's what I've got. To convert millage rates to dollar rate amounts, divide each mill rate by 1,000. Then multiply the result by the property's taxable value to compute the property tax. So that's one type of tax. But wait, there's more. There is an estate tax. That too is permitted under Florida's Constitution. Before I move on, the ad valorem taxation is permitted under Florida's Constitution, not permitted to Florida's legislature, but permitted to all the lesser sovereigns, permitted, for example, to counties and municipalities. So it won't be the Florida legislature imposing the ad valorem taxation on you, but it can be your county, can be your city, can be your school board. can be a multitude of intergovernmental agencies, relationships, and other lesser sovereigns below the statewide level. Turning now to the estate tax. Is an estate tax allowed in Florida? Yes, but it's tied to the federal tax. An estate tax, as you know, taxes property that is transferred after death. So it's not the kind of thing that often you can draft your way around in the estate plan, because if it falls into the estate plan, that means it's going to be transferred after death, and that means you're going to pay that estate tax. So you might do some pre-death transfers, but in general, if it falls into the estate plan, that's not a good way to avoid the estate tax. In Florida, if there's no federal estate tax due, then you don't owe an estate tax to Florida either. That's embodied in Florida law. So as federal estate tax law changes, perhaps it changes for the better, perhaps it means less money is taxed or less individuals face the tax, then likewise, less money is taxed and fewer individuals face the tax in Florida, because they're tied together in that way. The Florida estate tax deduction for estate taxes paid by the estate to the federal government and to other states. What I mean by that is, say ultimately here in Florida, the estate owes estate taxes. It gets to deduct from the Florida estate tax bill what it paid in federal estate taxes. It also gets to deduct from the Florida estate tax bill what it paid to any other state. And it can be that a given estate might own real property that's located in another state, might own personal property that is mobile that another state is claiming the right to tax, such as an airplane or something like that. So to the extent that you get hit by an estate tax in another state, you can subtract that from your Florida estate tax due, just like you can subtract your federal estate tax. And in Florida probate, the personal representative, you remember, that's what Florida calls our executor or executrix. The personal representative, or PR, has to file an affidavit before the probate estate can be closed. An affidavit stating that either the Florida estate tax has been paid, or the personal representative can swear that there is no Florida estate tax due. If ultimately they speak falsely, then of course that's perjury. So that's one way that this is enforced. Another type of tax, we've already had ad valorem taxes, we've already had estate taxes. Here under Florida's Constitution, you will also see a gross receipts tax. Gross receipts tax. Unlike a sales and use tax, and if you buy anything in Florida, you know they're adding at least 6%, 6.5%, 6.75%. We'll get to those details when we talk about the sales and use tax. But unlike a sales and use tax, which is imposed upon buyers, a gross receipts tax is imposed upon sellers. So the sellers might also be paying property tax. They might also be paying ad valorem taxes. They themselves, depending on what exemption they have, might also be paying sales and use taxes. And on top of that, they may be paying gross receipt tax. And it's gross, not net. Understand that accounting term. Gross is the full amount that comes in. Net is what's left over after certain subtractions and deductions. So we're not talking about a net receipt tax, we're talking about a gross receipt tax. It's not a violation of Florida's Constitution and Florida Constitution's restriction upon personal income taxes for there to be this gross receipts tax. So that's okay. Now, the gross receipts tax doesn't apply to everyone and everything. Instead, it applies to those that the statute identifies and the instances of sales or industry or entity to which the statute says it applies. So that, again, is another difference between the sales and use tax and the gross receipts tax. The sales and use tax applies to anything sold or used unless there's an exception or an exemption. It's the opposite with the gross receipts tax. It only applies if it's an enumerated instance of application. There's also a federal interstate commerce clause, constitutional law issue here. SCOTUS requires four things. First, there's got to be that substantial nexus between the taxing state and the individual being taxed. Second, there can't be an unfair instance of multiple taxation. So each taxing state that has the substantial nexus has to take into account and has to modify its ultimate taxable recovery based upon what the other states have done for the same individual in this same gross receipt. Third, it can't be discriminatory, by which we mean we can't favor in-state payers or in-state citizens in favor of out-of-state. We can't give Floridians a break only, and that break is not extended to non-Floridians. We can't tax those gross receipt tax payers differently based on the fact that they're not Floridians. And the fourth requirement from SCOTUS, it has to be fairly related. So those are the four requirements that you find under the Interstate Commerce Clause. I hope I'm ringing a bell. Hope you remember that from Federal Common Law 1. And here's where you see it applied under Florida's Constitution too. So the gross receipts tax, what's an example of that? Well, how about your electric company? After you pay your electric bill, and everyone else does, the gross amount of money that comes in, the electric company owes a tax on that. Hey, wait a minute, you say. On the bill, I saw taxes. Yeah, those were sales and use taxes. Those were utility taxes. You pay those. But in addition, after you pay those, the gross receipts from the utility company pays a tax on that. Sound like double taxation? Sound like triple taxation? Wake up, people. Double and triple taxation is everywhere, for better or for worse. No exception under Florida's Constitution. Let's talk about another type of tax. So many taxes. This is the excise tax, not exercise tax. I'm looking for tax jokes. They're hard to find. But excise tax. What is an excise tax? An excise tax is a tax that's not imposed directly upon persons or property. For example, intangible property. So the excise tax only applies upon enumerated items, like we mentioned with an earlier instance of tax. This is different from the sales and use tax. The sales and use tax applies to any instance of a sales or use unless there's an exception. Here, there is no excise tax unless the thing you're trying to place the excise tax on is on the statutory list of enumerated items. Another thing that's different about the excise tax, and which you should take note, it is not uniform. On that list of enumerated things for which there is an excise tax, the rate might be different for different things. It's allowed to be different for different things, higher for some, lower for others, need not be uniform, and indeed it is not uniform here in Florida. Excise taxes are computed in one of two ways, either computed on a per unit basis or computed on a percentage of the purchase price. One of those two, depending upon the particular enumerated item in the enumerated list. Different taxing authorities will impose different calculations of value upon the same item subject to the excise tax. So if you happen to have an item on the enumerated list that is enumerated to owe an excise tax to the state of Florida, and also happens to be enumerated to owe an excise tax to that particular county, it's no defense if the county says it's worth more for you to argue, well, the state valued it less. Each sovereign gets to place its own value, even though it's the same item. So different taxing authorities can use different values to compute their excise tax on that one and same thing. Examples: tax upon the purchase of electricity. So you get your electric bill and you look, you use this many kilowatts at that much per kilowatt, but you also owe a tax on that. And those two subtotals, along with the other subtotals, become your total electric bill. Here's another example, Florida's dock stamp tax. And this is higher than in many other states. If you've bought any real estate here, or perhaps you've entered into a contract that requires it to have some doc stamps on it, you're going to pay a tax to the state of Florida to record that document. Indeed, you're not going to be able to enforce that document if you failed to pay the doc stamps. That can be a defense to breach of contract. The contract didn't pay the doc stamps on it. That can be a defense to foreclosure. They didn't pay the doc stamps on the mortgage and on the deed. And each one of these documents is going to pay a doc stamp based on the value on its face and the number of pages. Sometimes you see a deed where the font starts to get really, really small. They're trying to save on the doc stamps here in Florida. They're trying to have one less page to pay doc stamps on. So this is another example of an excise tax. How about the sales and use tax? You're familiar with that. You may even call it the sales tax. That would be a misnomer, especially here in Florida. You've got to call it the sales and use tax. Why is that? Because you don't have to buy and sell. You don't have to have a sale in order to owe the sales and use tax. You might know that depending on whether or not you rent and what the terms of the lease are. Particularly in a commercial lease setting, you're going to pay the monthly rent and you're going to pay the sales and use tax. What if you're a Florida lawyer and you're a successful one, Lord willing, I'm rooting for you, and you run your own firm, so you decide to buy your own building. Maybe it's a condominium, maybe it's a mega tower towering over a major city. Maybe it's a small house you use as an office, but for whatever reason, you buy some property to be your commercial office space. Now, if you studied certain types of law, you probably would understand that it might be beneficial to have separate corporations. You have the law firm as Law Office of Me, PA, or Law Office of Me, Inc., or Law Office of Me, LLC. And then you have My Property, LLC, My Property, Inc., My Property, C Corp, whatever you might choose. You might have two separate legal entities to keep separate your operating business and your real estate holdings. Now you're going to owe use tax every month that you use your own property. Wait a minute, McGinley. I didn't sign a lease with myself. The state of Florida doesn't care. There's two entities there. There's your law firm and there's the owner of the property. Likewise, maybe you're practicing with partners and you're X and Y PA or X and Y Inc. and you own the property, not the other partner. Well, again, two entities. You're going to owe sales and use tax. But no money changed hands, McGinley. I didn't pay any rent to myself. Doesn't matter, says the state of Florida. Still owe sales and use tax. So it's important to understand it's not just a sales tax. And it's not just the state of Florida that's taxing you. It's imposed statewide. We all know it to be a minimum 6% because that's what the Florida legislature, that's what their take, that's what their cut, that's what their sales and use tax is. But there's also a local option. What local options are we familiar with? How about the discretionary sales tax? The proponents of it love to call it, oh, it's the half-penny sales tax. Yeah, it's 0.5% on every dollar you ever spend almost. Hard to look at that as some sort of half of a penny. That adds up quickly. And that becomes 6.5 or 7 or 7.25, depending on what Florida county you're in. On top of that are fuel taxes. Ever notice as you travel that no two gas stations charge the same for gas? Not only is that a function of supply and demand, it's also a function of local fuel taxes. So where they are might be taxing you. How about transient rental taxes? Ever stay in a hotel? Ever rent an Airbnb? You're going to pay an additional tax to the local authorities, perhaps not just the county, but maybe the county and the city that it's located in. You might owe 3 taxes there. How about tourist development taxes? We love our tourists. They bring us money here in Florida, but we take from them too with these tourist development taxes. How about food and beverage taxes? Go out to a restaurant, go out to a bar, even go through the drive-through. You pay not only the 6% tax, but the local option, and then maybe even a specific tax for food and beverage on top of the local option. What about municipal resort taxes? What about convention development taxes? What about impact taxes? What about gas taxes? I got to keep shrinking the font because there's so many of these taxes. If we were to pick among all the taxes we talked about as to what statewide generates the most money added up in the aggregate, clearly it's the sales and use tax. There's just so many, and that's a non-exclusive list. There's just so many ways that you find that tax is applicable. So that's the taxes we've looked at: sales and use, excise, gross receipt, estate taxes, ad valorem taxation. Everybody's getting taxed, right? So that leads to my next question. Who is liable for the taxes? You? Yeah. As a Floridian? How about as a visitor visiting Florida? Yeah. How about as a corporation incorporated in Florida? Certainly. How about as a foreign corporation doing business in Florida? Yes, absolutely. How about sovereigns within Florida? What about this question? Take a look at that question. Does the state of Florida, its agencies, its counties, and its municipal corporations pay taxes to the state of Florida? We know that the county's taxing us. We know that the city's taxing us. Does the city pay taxes? Does the county pay taxes to the state of Florida? And here's the answer to that. Let me break it down into 3 separate bullets. First, the state and its counties are immune from state of Florida taxation. But unlike counties, municipalities are not subdivisions of the state and are therefore subject to taxation absent an exception, or an exemption is what we call that type of exception in state and local tax lingo. So when it comes to the state of Florida paying taxes to the state of Florida, immune. When it comes to a county paying taxes to the state of Florida, immune. When it comes to a city, a town, a township, a village, the villages, another municipal corporation, they are subject to taxation by the state of Florida unless there's an exemption in place for them. And the third bullet to consider goes to Article Section 3A of Florida's Constitution. That section confers upon property owned by municipalities an exemption. So here's an example of one of those exemptions. It provides in Article 7, Section 3A, an exemption from ad valorem taxation, from that one particular type of taxation, if the property is owned by the municipality and is used exclusively for municipal purposes. So if those 2 criteria are met, then we have an exemption. Does the state of Florida, its agencies, its counties, and its municipal corporations pay taxes to Florida? The answer is yes. And now in this very exciting lecture, I hope it hasn't been death by PowerPoint. It's hard to bring taxation to life. And our break at this point is well earned. I've got 6:56 on my clock. Let's call it 7:12, shall we? At 7:12, we'll come on back. And if I could see y'all in person, I'd give a personal award to all those who managed to stay awake through a tax lecture. I think that's a noble thing to be able to do. But for those of you who are loving every minute of it, wait, there's more. I'll see you at 7:12, and we'll talk some more taxes. See you then. still here? Thank you. I didn't write all these books, just the green ones. Okay, welcome back. How many books in the room? Got the Southern Second, starts at number 1 over there, but I quit bio at number 628. So anyway, welcome back. It was a joke, I guess, when I said it felt like death by PowerPoint, but when I thought about it, that's not funny. So I'm gonna turn off the PowerPoints. I'm a lawyer, not a comedian, but I'm going to try to bring tax law to life. But let's have sympathy for those lawyers that actually practice tax law for a living. Hey, they're doing it. God bless them. Somebody's got you, right? But if you think about it, you're probably going to practice federal tax law, right? We don't have a state income tax. There's certainly some tax issues. Could show up in the bar exam. It could show up in your real life. I talked about how was the sales and use tax, and if you're gonna own a firm, gonna perhaps buy office space, you have to worry about sales and use tax. So this material, although maybe not as exciting as some of the other material in our class, it's useful, it's practical, it's day-to-day hard knock stuff. What I'm trying to say is stay with me here. I'll try to keep you awake, I promise. All right. So we talked about all kinds of different taxes, and we've had all kinds of different PowerPoints about them. Let's talk about some non-revenue tax sources. What about those entities that they need more money for whatever reason? They don't have the authority to tax. I don't know. Maybe they've used up all their authority and they still want more money. Government can be that way sometimes, right? Sometimes money's like closet space. You never have enough. Feels that way anyway. So what about those governments? There's a difference between what is a tax and what is not a tax. And although a particular government, be it the state of Florida, be it a county, be it a municipality, be it a agency, be it a intergovernmental organization, whatever lesser sovereign, lesser than the state of Florida you find that's allowed by Florida's Constitution, they may have a need for additional revenue. And they have the right to turn to non-tax sources to gain that revenue. So let's talk about some non-tax revenue sources. And probably the right way to begin that discussion is the way that I began it in this section of the text, and that is to define the word tax, at least insofar as it is defined under Florida's Constitution. Now, the Supreme Court of Florida defines the word tax under Florida's Constitution as follows: an enforced burden imposed by sovereign right for the support of the government, the administration of law, and the exercise of various functions the sovereign is called on to perform. Quote from State versus City of Port Orange, a 1994 decision from the Florida Supreme Court. Despite that very broad language, not every financial obligation imposed by a sovereign meets this definition of tax. Governmental entities that lack the power to tax, they can still impose financial obligations so long as those obligations don't meet the definition of tax. They can do so in one of two instances. Either one, a Florida statute has granted the power, or 2, the entity has home rule powers. And I'm hearkening you back now to prior lectures when we talked about home rule powers. So either through the home rule power or through a Florida statute, a particular sovereign may have the right to non-tax revenue sources. There's a constitutional restriction upon that. In order for the non-tax revenue source to be valid, the non-tax financial obligations must meet certain requirements. That's why I included the case of Morris versus City of Cape Coral to help you understand and to illustrate what those constitutional requirements are. Now, in Morris versus City of Cape Coral, the facts involved the City of Cape Coral imposing a special assessment. A special assessment. What is a special assessment? It is one of the multitude of non-tax revenue sources. Sure, doesn't meet the definition of a tax, but if you're the landowner who's subject to a special assessment, it probably feels a lot like a tax to you, because just like a tax, you're paying it as part of your tax bill. Just like a tax, you're paying it to the government, to a sovereign. Just like a tax, if you don't pay the special assessment that's been levied upon your real property, they're going to foreclose and take away your real property. So it doesn't meet the definition of a tax, but for the payer of the special assessment, it probably feels a lot like a tax. So what's going on in Morris versus City of Cape Coral? They're worried about fire. They want to have adequate firefighting and fire prevention services. So they've hired this Burton and Associates. They're going to prepare a study about the city's fire protection services. Where are they needed? Where do the costs arise from? Who's benefiting from these fire services? And how can we match up the costs with the benefits? Those who benefit bearing the costs. And that's what the city ultimately passes an ordinance about. And what they come up with is the city and the landowners don't all pay the same. There's a tier 1 and a tier 2. And tier 1 and tier 2 are paying different amounts based on what the city and their consultants and the city voted to impose as different special assessments. So 4 property owners file a notice of appeal, and we have the decision that you've read here. Now, notice the standard of review. The court's scope of review is limited. First, to whether the municipality has the authority to issue the assessment. Second, whether the purpose of the assessment is legal. And third, whether the assessment complies with the requirements of the law. To answer all 3 questions, I got to jump around the opinion just a little bit, but not so much that you can't keep up with me. First, whether the municipality has the authority to issue the assessment. That's where we go under the heading of analysis. It says here, the authority to issue special assessments under municipalities' home rule powers exists. And it quotes a case that says a municipality that has home rule powers may exercise any governmental, corporate, or proprietary power for a municipal purpose. You remember that from our prior discussions. When did a municipality have a municipal purpose? When it acted on purpose. If it didn't do it by accident, if it did it on purpose, then it did it with a municipal purpose. Remember that? So, a municipality may exercise any governmental, corporate, or proprietary power for a municipal purpose, except when expressly prohibited by law. And a municipality may legislate on any subject matter on which the legislature may act. Do you remember that from our prior chapter called Lawmaking and Its Limits? Just because the Florida legislature can and has passed a law on a particular topic, that doesn't necessarily mean that a county or even a city or other municipality can't legislate on the exact same topic. Indeed, unless there is either express or implied preemption, all those sovereigns, the state, the county, the city, and other municipalities can all legislate on the exact same topic at the exact same time.
Therefore, concludes the analysis here, it would appear that the city of Boca Raton can levy its special assessment unless it is expressly prohibited. Accordingly, the city of Cape Coral has that authority and, quote, there is no question that the city of Cape Coral had the legal authority to levy the special assessment. So, what's a county to do? Of course, or a city. What's a city to do? Of course, a city has to provide firefighting services. Of course it does. Through volunteers or through paid. And if you don't have enough volunteers, you're going to have to pay. Does that mean I can make a special assessment just to pay for the firefighting services? The answer is yes. The next question is, what about those two tiers, tier 1 and tier 2? Everybody's not paying the same. So the court scope of review was limited to 1, whether the municipality has the authority to issue the assessment. The answer there was yes. Number 2, whether the purpose of the assessment is legal. Firefighting? Yes, that was legal. And in this opinion, they quote to various other opinions where other cities had special assessments for exactly that same purpose. But that's not the takeaway for you. The takeaway for you was what? A municipal purpose. When does a municipality act with a municipal purpose? When it acts on purpose. When it didn't do it by mistake. So understand the depth and the broadness of that power. We can't argue, well, that's what the government does. You got to fight fires. I'm paying taxes. My taxes are for you to fight fires. Maybe, maybe not. The taxes won't be for fighting fires if instead they choose to impose a special assessment for that purpose. So that's number 2. Number 3, whether the assessment complies with the requirements of the law. This is the next important takeaway for you from this case. Special assessment. Can you have them? Yeah. Can you have them for things as basic as firefighting and other basic government functions? Yes. But question 3 is, when? What's the test? What is the 2-prong inquiry? And here it is. A valid special assessment must meet 2 requirements. 1, the property assessed must derive a special benefit from the services provided. And 2, the assessment must fairly and reasonably be apportioned according to the benefits received. Remember, at the outset of this case, as I described the facts, one of the first things the city manager of the city of Cape Coral did was to hire that consulting firm, Burton and Associates, to prepare the study so they could determine where the costs were coming from, what the appropriate costs were, but more importantly, to find out who was getting the benefits and to attempt to match up the costs with the benefits. Why was that step 1? Why was that done? Because a valid assessment has to meet 2 requirements. First, the property assessed must derive a special benefit from the services provided. And 2, the assessment must be fairly and reasonably apportioned according to the benefits received. So here there was tier 1 and there was tier 2. We were treating different citizens differently. Can we do that under a special assessment? Yes, we can. That is constitutional. That is permitted. That is not a violation of Florida's Constitution, because those are the 2 prongs there. We're going to find out who's getting the special assessment. We're going to reasonably and fairly apportion it according to the benefits received. Perhaps it is true, even with something as basic as firefighting, that certain properties are getting more benefits than others. If so, then we can have a tier 1 and a tier 2 where we're charging more special assessment to one and less to another. That is permitted. So, with that noted, in this case, quote, the City of Cape Coral has established that the assessed property received a special benefit. And ultimately, tier 1 and tier 2, that system of special assessment was upheld Conclusion, says the opinion, for the foregoing reasons, we affirm the final judgment of validation. In other words, the special assessment is indeed valid. So let's take a look at the notes and questions to consider. Note and question consider number one. What is a special assessment and why would a municipal corporation impose one? I hope the case illustrated that well. But we note under note one, cities impose special assessments to generate revenue, to pay for services, or to pay for capital improvements. These special assessments are estimated by assessing a charge on properties that receive a special benefit. Special assessments and ad valorem property taxes are similar, but they are not the same. They're similar insofar as payment is mandatory. They're similar in that they're both levied upon real property, but they're not the same. The central distinction is that special assessments must confer a specific benefit upon the land burdened by the assessment, whereas ad valorem taxation doesn't have to confer a special benefit upon the land burdened by the assessment. For example, you may or may not have children if you are a Florida landowner. But regardless of whether or not you have children, part of your Florida ad valorem bill, part of your Florida property tax bill will be an assessment to help fund the schools in your area. You don't have children. Maybe you don't want children. Maybe you'll never have children. Maybe you can't have children. Do any of those factors mean you don't have to pay the portion of the ad valorem property taxes that go to the school? No, you're paying them anyway. When it comes to the ad valorem taxation, it doesn't matter whether a particular parcel gets any benefits whatsoever, may never see a benefit at all, but still owes the ad valorem tax. That's different than the special assessment. We've got to meet the two prongs. We've got to both find that there is a special benefit for that particular parcel, and we have to find that we've fairly and reasonably apportioned according to the benefits received. That's true for a special assessment. That's not true for ad valorem taxation. Let's take a look at notes and questions to consider. Number two. Number two asks, what satisfies the first prong of the two-prong tests for the validity of a special assessment? You remember that was the special benefit prong. Note 2 tells us the following. It is satisfied when that portion of the community which is required to pay it must receive some special or peculiar benefit in the enhancement of value of the property against which it is imposed as a result of the improvement made with the proceeds of the special assessment. It is limited to the property benefited, is not governed by uniformity, and may be determined legislatively or judicially. And I'm quoting way back there from a 1930 decision of the Supreme Court of Florida. Stated somewhat differently, the property of the taxpayer must be deemed by the legislative authority to be benefited over and beyond the general benefit to the community. And it is imposed and collected as an equivalent for that benefit and to pay for the improvement in whole or in part. That was the first prong, the special benefit prong. And as we turn to the next note, note 3 under notes and questions to consider, we turn then to the second prong. Note 3 asks, what satisfies the second prong of the two-prong test for validity of a special assessment? You remember that was the fair apportionment prong. The note tells us the following by quoting from a 1962 decision of Florida Supreme Court. Quote, to be legal, special assessments must be directly proportionate to the benefits to the property upon which they are levied. And this may not be inferred from a situation where all property in a district is assessed for the benefit of the whole on the theory that individual parcels are peculiarly benefited in the ratio that the assessed value of each bears to the total value of all property in the district. So you understand then what we're talking about in the fair apportionment prong. Like most constitutional law questions, we have here a question of reasonableness. And to flip back to the Morris versus City of Cape Coral opinion, I think this part tells us well how to interpret that second prong. Let me quote it to you. It is from the second full paragraph of the opinion under the opinion's heading that reads standard of review. It says here, I'll read it to you. These two prongs both constitute questions of fact for a legislative body rather than the judiciary. These two prongs both constitute questions of fact for a legislative body rather than the judiciary. We hear findings of fact, we think what? We think a judge, we think witnesses, we think evidence. And certainly witnesses and evidence, but not a judge, a legislature. What we're talking about with special assessments are questions of fact that are decided by the legislative, not the judiciary. What's the judicial review of the legislative? Arbitrary. The question for the judiciary is, was the legislative body arbitrary? Did it act in an arbitrary manner? If it was not arbitrary, then it should be upheld when it comes to the legislative findings of fact supporting a special assessment. What does arbitrary mean? Let me give you a definition of arbitrary. Okay. Flip a coin. Arbitrary. Pull a number out of a hat. Arbitrary. Wait and see if a blue car or a red car passes the window first. Arbitrary. Let me give you examples of things that aren't arbitrary right here in the opinion. Cape Coral authorized its city manager to hire Burton and Associates to prepare a study. After spending that money, the professionals came back with a report. After analyzing the report, they held a public meeting. The city read and approved an assessment ordinance. It was again read and approved at a July meeting after having been done at the June meeting. City also passed a note ordinance at the same meeting. Thereafter, an initial assessment resolution was adopted. In July, thereafter, a final assessment resolution was adopted in August. What you see here is a city that's not being arbitrary. They're involving the citizenry. They're turning to experts. They're trying to quantify the costs and quantify the benefits. Ultimately, does Tier 1 like paying more than Tier 2? I'm sure they don't. But was it arbitrary to tell Tier 1 to pay more than Tier 2? No. No one flipped a coin. No one pulled a number out of a hat. Mathematics were done. Was the math imprecise? Was it politically motivated? That's not the judicial standard. The judiciary reviews to determine whether or not it was arbitrary. If it wasn't arbitrary, then it's upheld. That's the key to the second prong. So I hope that case was a good illustration of special assessment. Let's turn now to a couple last points in the notes and questions to consider to make before we move on to just valuation, just meaning fair. Note 6 under the notes and questions to consider points out that sovereign immunity, you remember our studies of sovereign immunity. Sovereign immunity protects Florida from liability to counties, municipal corporations, and districts who might enact a special assessment. Therefore, neither the state of Florida nor its state agencies may be liable for a special assessment unless a law passed by Florida's legislature permits it. So who pays the tax? Well, the landowners, right? What if one of the landowners is the state of Florida? They ain't paying. Why not? Sovereign immunity. Can sovereign immunity be waived? Of course. Our Constitution says laws may be made that waive sovereign immunity. But unless and until they are, you could put as many special assessments on the state of Florida's land that happens to reside in your county as you want. They ain't writing you any checks. Note 7 under notes and questions to consider. In lieu of a special assessment, another funding method used by Florida's government entities who either lack the power of tax or just spend all their tax money and want another source of revenue. Another, in addition to the special assessment, is the user fee. Examples include utility fees for sewer, electric, park pavilion rental fees, permits, licenses, and the like. User fees are charges based upon the proprietary right of the governing body permitting the use of the instrumentality involved. Such fees share common traits that distinguish them from taxes. They're charged in exchange for a particular government service, which benefits the party paying the fee in a manner not shared by other members of society. They're paid by choice. They're paid by choice. You can avoid user fees, in that the party paying the fee has the option of not utilizing the governmental service and thereby avoiding the charge. Therefore, a financial obligation meets the definition of a user fee if it's an avoidable charge paid voluntarily in return for use of a thing or service provided by the government entity. Now, when is a user fee valid? It's valid when it meets the following requirements. First, the fee must bear a rational relationship to the per capita cost of thing or service. Notice again, in constitutional law, is there a lower standard than rational relationship? No, but there's got to be a rational relationship between the per capita cost of the thing or service and the user fee. That's the first requirement. Second, the fee must be used by the government body toward its expense in owning, maintaining, or providing the thing or service. Home rule powers, whether granted by the state constitution or the state legislature, those are sufficient as authority for imposing user fees. If the governmental entity has home rule powers, then an enabling statutes from Florida legislature is not a necessary prerequisite to charging user fees. Let me give you the most basic of examples. 9 years ago was Patrick's first birthday, and he loves Kraft Azalea Park in Winter Park, which is just off the Minnesota intersection of Minnesota and Azalea Lane. He loves it because the railroad track goes by, which back then he called the Choo Choo. Choo Choo Park was his favorite park. Now, Choo Choo Park has a playground. You can run around and play. It doesn't matter who you are. But Choo Choo Park also has a shaded pavilion. And if you've noticed me, you might conclude that I sunburn easily, and I do, even in December, which is Patrick's birthday. He was born on the Feast of the Immaculate Conception, December 8th. So I wanted some shade that day, and I was willing to pay the user fee to have the shaded pavilion. Well, that day there were some other fellow citizens of the city of Winter Park that were playing in the park. That's fine. But they also wanted some shade under my pavilion, and I had to politely tell them that I had written a check to the city of Winter Park, and that's why they had hung up this 8.5 by 11 piece of paper here in the glass that said the pavilion was all mine for the next 3 hours. And if they didn't mind, please getting out from under the shade so we could enjoy Patrick's birthday with all his friends and our friends, we sure would appreciate their kindness in doing that. Maybe that was selfish on my part, but on the other hand, I paid the user fee. I was entitled to the shade. And that is a definition of a user fee. So with that in mind now, let's turn to just valuation. Article 7, Section 4. Article 7, Section 4 of Florida's Constitution requires that ad valorem taxation be calculated by multiplying the millage rate by the just valuation of the property. Florida Supreme Court holds that the just valuation at which property must be assessed under the Constitution is synonymous with fair market value. And you've heard this definition of fair market value before. The amount a purchaser willing but not obligated to buy would pay to a seller who is willing but not obligated to sell. That's fair market value. Now, Strawn versus GAC Properties, Inc. poses a very interesting illustration of fair market value. Interesting insofar as that GAC Properties owns a large tract of undeveloped land. The land, however, has an imaginary line cutting through it. Imaginary because no matter how hard you stare, you'll never see it. It's the county line. It's the line between Osceola County, Florida, and Polk County, Florida. This one undivided, undeveloped tract of land happens to reside partially in Osceola and partially in Polk. So is Osceola going to tax it? Yeah. Is Polk going to tax it? Yeah. They're both going to tax it based on what? Just valuation. How's just valuation determined? It's the amount a purchaser willing but not obligated to buy would pay to a seller who's willing but not obligated to sell. But who determines that? A constitutional officer. A constitutional officer called the property appraiser. Don't forget that Article 8, Section 1 of Florida's Constitution says there shall be elected by the electors of each county for terms of 4 years a tax collector and a property appraiser. We talked about that when we talked about government in earlier chapters. One property appraiser for Polk came up with one value. The property appraiser for Osceola came up with the other. Of course, the one that valued it higher was not loved by the property owner, and that assessment was challenged. Can one property have two values? Yeah, it can. End of the opinion says the following: we decline to hold, merely on the basis of an allegation that different values have been assigned to adjacent properties of like character in different counties, that a taxpayer can claim a violation of the just valuation requirement of Florida's Constitution. What? This is more than just adjacent properties of like character. This is one piece of property. Ain't nobody divided this piece of property except for an imaginary line. But yet, the same piece of property has two different values based on two different constitutional officers, two different county property appraisers. Notes and questions to consider for Strawn versus JC property. Note 1. This case involved just a single parcel of land which happened to lie in two separate counties. One county said it was worth $300, the other $500. How did it arise that this one parcel would be assigned two different values using the same applicable law? Did one constitutional officer, the county property appraiser, use the wrong law? No. Did one use a different law? No. How then did they arrive at different values? What explains it? Subsidiarity. Subsidiarity. You remember that. You wrote some essays about subsidiarity. Did a brilliant job. Loved reading them. Wasn't a single bad one in the batch. And subsidiarity gives each of these constitutional officers, each county property appraiser, the constitutional right to use this formula and arrive at their own just valuation. No, they didn't match for the same piece of property. But they weren't arbitrary. There was a rational relationship. There's nothing unconstitutional. And the fact that they arrived at different numbers didn't make either one of them wrong. Subsidiarity. Let's talk now about Save Our Homes. And that'll leave us with just a bare amount of time to talk about a fun case, Northern Palm Beach County Water Control District versus State of Florida. But to get to Northern Palm Beach County Water Control District, I got to blow through Save Our Homes. So here it is. Are you ready? Save Our Homes says that despite the fact that your property might go up every year, if it's homestead, this year's bill can't be more than 3% higher than last year's bill. That's true every year. If it's non-homestead commercial property, this year's property tax bill can't be more than 10% higher than last year's bill. Save Our Homes and the 3% for homestead was made portable by an amendment to Florida's Constitution. What's meant by that? Portability. Well, if you imagine you stay in the same house for a long period of time, and theoretically the value keeps going up, but the tax only goes up 3%, eventually as the value goes up, there'll be a large gap between the true just valuation and what you're paying. because you couldn't pay more than 3% per year. That large gap, you can take it with you when you buy and reside in a new homestead. Maybe you were paying 90%. Maybe you're paying 88% based on that big gap. You take the 90 or the 88% with you when you settle a new homestead. So that's Save Our Homes. That's Save Our Homes portability. That is another benefit of reduced taxation thanks to Homestead. And that brings us to a joy of a case, which goes under the heading of finance, not taxation. And here we've got the permissible purpose of pledging credit. And this case stretches the very boundaries. I'll cover it for just another 90 seconds, and that'll get us out of here on time. In Northern Palm Beach County Water Control District versus State of Florida, they decided that they could do some tax-exempt bonds in order to develop this property. And the majority found that Article 7, Section 10 of Florida's Constitution prohibits the state of Florida and subdivisions, including special districts such as its water control district, from using its taxing power or pledging public credit to aid any private person or entity. However, there was no violation here, said the majority. But the dissent is a joy to read. Turns out that these tax-exempt bonds were being used to create a Caribbean island motif, extensive landscaping. The overall theme of the development is to provide a Caribbean island effect. Strong emphasis is the roadway planning, various palm species 20 to 30 feet high, full canopy backdrop, accented with dwarf palms and a wide variety of blooming ground cover plants. The remaining open areas will be sodded. The most extensive landscaping treatment is in the median, followed by right-of-way adjacent to a development parcel, then right-of-way adjacent to lake open areas. But most egregious was the security gatehouse. The district will also pay for construction and maintenance of 3 gatehouses to be staffed by security personnel. Their purpose? To block and prevent all public access to the private club. So the dissent's arguing, how is this for a public purpose if the public isn't allowed? Part of the money is being used to build a gatehouse to keep the public out. But yet, this met the definition. And the short answer as to why this was still a public purpose, again, municipality does it on purpose, meets the definition of municipal purpose, and the low standard of review. Rational relationship, not arbitrary. That's the constitutional standard to be applied here. So you've done it. If you're still awake, you've managed to stay awake through an entire lecture on taxation. We'll proceed to the next chapter in our book. We're done with taxation and finance from here on out. If I covered it here and therefore covered it in the text, you can see it on the test. If I didn't cover that portion of this chapter in the text, you won't see it on the test. So enjoy reading or rereading the parts that we talked about or alluded to in this lecture, and know those parts well. And while you enjoy that reading, please, may the Lord our God continue to bless us all. Stay safe. Thank you for joining me. See you next week. God bless you.